The Texas abortion law, known as House Bill 2, was controversial from the start. Pro-choice lawmakers tried to filibuster the measure, and when it finally came to a vote, protesters had to be forcibly removed from the gallery. Anti-abortion forces are strong in Texas, and the measure passed easily.
In signing House Bill 2 today, we celebrate and further cement the foundation on which the culture of life in Texas is built upon.
Among other things, the law requires that doctors performing abortions have admitting privileges at a hospital within 30 miles of where the procedure is performed, and that all abortions be performed in what's called an ambulatory surgical center, a sort of mini hospital. The avowed purpose of the law, to make abortions more safe. The law is being challenged by Whole Woman's Health, a chain of 5 abortion clinics, 3 in Texas, 2 in Virginia.
It sounds like the state has women's safety in their interest, but closing 3/4 of the clinics and requiring women to travel 500 miles for a 5-minute procedure, they don't have people's safety in mind. We've seen a spike in self-induction. We've seen a spike in women trying to do abortions on themselves. That is not in the best interest of women's health and safety.
The Supreme Court is a court of law, not facts. There are no witnesses here and no juries. The court examines a statute like the one in Texas to see if it is consistent with the Constitution. In most cases, the justices are bound by the facts in the lower court record. Here, however, those facts are in sharp dispute, both as to the purpose of the law and its effect. State Senator Ken Paxton was a driving force behind the law when it was passed in 2013. Today, Paxton is the Attorney General in Texas and is leading the effort to defend the Texas law in the Supreme Court.
Every week, 2 to 3 women have major complications from abortions. We have 10 a week that are in emergency rooms. We have 210 every year who have to be hospitalized, and so those are the women that we're worried about.
It's just not the case. Abortion is one of the safest medical procedures.
The abortion clinics will be represented by the New York-based Center for Reproductive Rights. Nancy Northup is its president.
In many cases, we have clinics who've gone 10 years, they haven't had one need to transfer a patient to a hospital for further care. So it's a way to sound like you're doing something safe for women, but really what you're doing is making women now not have a clinic in their neighborhood and have to go hundreds and hundreds of miles.
Every major city that, or every city that has an abortion provider now will still have an abortion provider. That's not changing.
Every city that now has an abortion provider will still have an abortion
Exactly.
provider. We certainly don't get that from the other side.
Sure you don't, but that's the fact.
Well, it's not the case because clinics have closed in Beaumont, Texas, and Killeen, Texas, and the McAllen Clinic is on the verge of closing. We sued because El Paso would have to close. So it's not the case. In fact, we put a map in our Supreme Court brief that just shows how many clinics have closed already in Texas and how they're spread across the state, particularly outside of the major cities.
The clinic in San Antonio does have a surgery section, but the plaintiffs say many clinics cannot afford that and that it is unnecessary. And because most abortions are not performed in hospitals, most doctors specializing in abortion cannot get hospital admitting privileges. The Supreme Court is getting plenty of advice on how to decide this case in roughly 90 friend of the court briefs representing hundreds of organizations, including one filed jointly by the American Medical Association and the American College of Obstetricians and Gynecologists, stating, "Abortion is an extremely safe medical procedure, and the Texas law imposes medically unnecessary demands on abortion facilities and serves no medical purpose." That echoes the findings of the trial judge, Lee Yackel, who concluded the Texas law creates a brutally effective system of abortion regulation, a statewide undue burden for substantial numbers of Texas women. All bewildering to Texas Attorney General Ken Paxton.
I remember thinking when we were arguing for this, why the people that were pro-abortion, why they wouldn't be in favor of more significant standards or safer standards for women. If that's really the issue is women's health and women's safety and women, then I've never understood why that wouldn't be appealing to the other side.
Why isn't that appealing to you?
Oh, the provision of safe abortion services within communities is of great interest to the women's health movement, and we support that. But what we don't support is a kind of backhanded attempt to get rid of health care in communities by passing these unnecessary, regulations.
This is one of several high-profile cases that could be profoundly affected by the death of Justice Antonin Scalia last month. Scalia had been the court's most forceful critic of any constitutional right to choose abortion. The court had been split on abortion rights 4-4, with Justice Anthony Kennedy thought to hold the decisive fifth vote in this case. But with Scalia now gone, the court might end up equally divided, and the case may have to be re-argued at a much later date, after Scalia's successor is confirmed. Until then, this is a scenario that is likely to repeat itself over and over again on those politically charged and socially contentious issues that divide the court as they do the country. For Religion and Ethics News Weekly, I'm Tim O'Brien in Washington.